Case 1 involves Leslie Janae Chance. When detectives returned to examine surveillance footage from a taxi service near Highway 43, the images did not fit the alibi she had already provided. A mysterious figure appeared miles from their supposed location on the morning of August 25, 2013. This review triggered a 3-year investigation. You and I are heading inside a Bakersfield principal's office to find out why. Leslie Janae Chance was a Bakersfield local through and through. After her first husband cheated during her pregnancy, she focused on raising her young daughter, Jessica, alone. She balanced 3 jobs to earn her teaching degree, eventually climbing the ranks within the Greenfield Union School District. There, she met security guard Todd Chance. They wed in 1996, and Leslie later became a respected elementary principal. Todd drove trucks, but by the early 2000s, Leslie had become the household's primary financial provider. Everything changed when a farmhand found a body near a remote almond orchard on August 25, 2013. Responding deputies found 45-year-old Todd Chance dead. He had been shot twice in the chest and once in the hand. Since his wallet was untouched, investigators quickly ruled out a robbery. Todd's .38 caliber revolver was found inside his abandoned Ford Mustang, along with 2 spent shell casings that were left behind. Leslie claimed she last saw Todd at 7:30 a.m. and noted that one of his handguns was recently missing. However, investigators soon uncovered Todd's hidden secret. Since 2012, he was sending flirtatious Facebook messages to an old flame named Carrie Williams. Prosecutors believed Leslie knew. They pointed to her fingerprint, found on the driver's side door of Todd's abandoned Mustang. Her DNA was also found on the gear shift, despite her claim she never drove her husband's car. Leslie remained free for years, collecting $500,000 from 4 separate life insurance policies. In December 2016, police moved in. Prosecutors had discovered something chilling about a family trip. Weeks before the murder, the family visited a CSI exhibit in Vegas, where a woman kills her husband. In that simulation, the woman hides the body in a remote, outdoor location. Prosecutors argued Leslie used this as a blueprint. After a mistrial, her second trial lasted over 4 weeks. The defense called the evidence circumstantial, claiming the grainy figure on the tapes was impossible to identify. After 8 days of deliberation, the jury returned a verdict. Leslie Janae Chance was guilty of first-degree murder. She was sentenced to 50 years to life, including a 25-year enhancement for the use of a firearm. In January 2023, an appeals court upheld her conviction for the brutal 50-year sentence. Today, she resides in a state prison, a principal who used a vacation to script a real-life killing. Now, you and I will look at a principal who stole school funds. Case 2, Cornelius Green. The financial irregularity that first surfaced during a review of Carl Lane Performing Arts Middle School's accounts was not immediately understood as a thread that would unravel a murder. An internal audit found a strange payment that had nothing to do with school events. Money from a student dance fundraiser had simply vanished without any proper paperwork. Cornelius Green was an ambitious educator who built his professional reputation in the urban schools of St. Louis. By his late 30s, he led Carl Lane Middle School while hiding a complex private life from the public. Green was secretly juggling multiple romantic relationships at the same time. One of those women was Jocelyn Dolores Peters, a teacher who believed Green was finally leaving his wife for her. By March 2016, Jocelyn was in her 3rd trimester, happily preparing invitations for her upcoming baby shower. The baby's name was already chosen, Micah Lee. On March 24th, Jocelyn was found shot to death in her St. Louis apartment. She was 30 weeks pregnant at the time. There was no forced entry. Chillingly, the killer used a piece of potato as a makeshift silencer for the handgun. Jocelyn was killed at her kitchen table. That same morning, Green took a train back from Chicago to discover the body. He called 911, acting the part of a grieving partner who had no idea what had happened. Cell phone records eventually pointed to Philip Cutler. Cutler, an old friend, was traced near the scene. You and I can see he had no connection to Jocelyn. He had traveled to St. Louis days earlier, staying at Green's home while Green conveniently left for a trip to Chicago. Investigators tracked a package from the school to Cutler, containing $2,500, the exact amount missing from the fundraiser. Green had actually stolen that money from his own students to fund the hit. While being held for questioning, Cutler was seen desperately swallowing 2 scraps of paper. By June 2016, both men were in handcuffs. The probe revealed Green had researched hiding abortion pills in food, even attempting to slip them to Peters without her knowing. When the poisoning failed, he reached out to Cutler instead. In March 2022, a federal grand jury indicted Green for murder for hire. By February 28, 2024, he stood in court and pleaded guilty to every count. At his sentencing on June 25, 2024, Peters' mother told the court Green was meant to protect her daughter, not become her executioner. Judge Ronnie White handed Green 2 back-to-back life sentences, ensuring he would never see parole. Just 1 week later, Cutler walked away with the exact same fate. The very money Green stole from the children he was supposed to lead became the blood price for the lives of Jocelyn Peters and her unborn daughter, Micah Lee. Next, let's look at our third case together, the story of Jane Muthoni. The investigation didn't start with a body, but with a sudden, unexplained absence. Solomon Mwangi, head of Kiru Boys High in Kenya, never showed up to collect national exam papers on November 7, 2016. It was the first morning of the high-stakes national secondary exams. Missing such a critical duty sparked an immediate search, and the case was soon escalated to criminal investigators. Jane Muthoni and Solomon Mwangi were both respected school principals. While Muthoni ran Ichachiri Girls, Mwangi led Kiru Boys. They shared a home and 3 children. The court heard how their marriage soured because Muthoni was convinced her husband was seeing a young woman at a money kiosk. But those suspicions had absolutely no basis in reality. The agent testified in court, denying any affair and showing texts where Muthoni had repeatedly threatened her to stay away. Detectives used 18 recovered texts and 21 witnesses to trace a plot brewing since June 2016. At least 2 failed poisoning attempts had been made before the final tragedy. A chemist found xylazine in Mwangi's liver, a powerful veterinary sedative usually meant for large animals. Muthoni had slipped it into his tea the night before he vanished. Once Mwangi was out, Muthoni drove him in the family minivan to a spot where the hitmen were waiting. Witness Joseph Kariuki took a plea deal and described the grim handoff. He claimed that as the sedative faded, Mwangi woke up and asked why Muthoni didn't kill him herself. Muthoni said nothing and drove off, leaving Kariuki and his accomplice to strangle her husband with a rope. They found his body at a coffee estate in Juja, stuffed in dirty sacks with horrific injuries to his head, torso, and legs. He died from strangulation. It would take nearly 5 years for the trial to conclude. Muthoni maintained her innocence, claiming rival principals had framed her. But on April 22, 2021, Justice Joel Nugi found them both guilty. In a massive 76-page ruling, the judge named Muthoni as the mastermind behind the entire plot. She was the financier, the one who supplied the drugs, and the person who delivered her husband to his killers. On June 3, 2021, both were sentenced to 30 years. Kariuki got 7 years for cooperating with the state. Today, Jane Muthoni remains behind bars at the Langata Women's Prison in Nairobi. Now, you and I must look at a case where the truth proved far more complicated. A Texas principal spent 33 years fighting a system that might have had the wrong man. This is Joe Bryan. One flashlight changed the case forever. Then, decades later, a single affidavit threatened to tear the whole conviction apart. In 2016, defense lawyers filed a formal complaint with the Texas Forensic Science Commission. They challenged the science behind the only physical evidence that linked Joe Bryan to his wife's murder. That complaint led to a shocking finding: the bloodstain analysis used to convict him twice was absolutely unreliable. Joe Bryan was the respected principal of Clifton High School in Boss County, Texas. He and his wife, Mickey, were pillars of their community. He ran the high school, and she taught 4th grade. By October 1985, Mickey was 35. Joe Bryan was attending a conference in Austin, 120 miles away, when his wife was killed. Mickey missed work on October 15, 1985. Her supervisor and parents found her lifeless body in the bedroom, shot 4 times at close range with a .357 revolver. There was no sign of forced entry. Joe claimed he spoke with Mickey around 9:15 p.m. the night before from his hotel in Austin. No witnesses saw him leave. No physical evidence tied him to the scene. He was arrested 8 days later. The prosecution relied on one item, a flashlight found in Joe's trunk by Mickey's brother 4 days later. Bloodstain analyst Robert Thorman testified that specks on the lens were actually backspatter, consistent with a close-range shooting, placing the flashlight right at the scene of the crime. Prosecutors argued Brian drove 120 miles through heavy rain, despite poor night vision, to kill his wife, then drove back to his hotel without leaving a trace. Brian was convicted in 1986 and given 99 years. His first conviction was overturned, but at his 1989 retrial, he received 99 years again. He became eligible for parole in 2007, but the board denied him 7 times for maintaining his innocence. A joint investigation by ProPublica and the New York Times Magazine in 2018 brought national attention, and experts concluded that Thorman's analysis had no scientific support. One expert called the findings egregiously wrong. Even Thorman later admitted his errors in an affidavit. New testimony pointed toward another suspect, former police officer Dennis Dunlap, who later died by suicide. His ex-wife claimed he admitted to being with Mickey the night of the murder. No new trial was granted. Brian was finally paroled in March 2020 at age 79, after 33 years inside. He died on September 22, 2024, at 84 years old. His conviction was never overturned. Joe Brian died legally guilty. He spent the final third of his life in prison, all because of a flashlight that an expert later admitted he misread. In Case 5, an internal audit first flagged Barbara Byrd Bennett, a series of no-bid contract awards totaling tens of millions of dollars that had bypassed the standard competitive procurement process at the Chicago public schools. No competing bids, no public solicitation, and no documented reason for the selection. When federal investigators from the U.S. Attorney's Office began examining the paper trail behind those contracts in 2012, they found not just a mistake, but a deliberate architecture, a corrupt scheme designed by the person at the top and operated for years, right from the CEO's own desk. Barbara Byrd Bennett was born in Harlem in 1949 and built a career in public education that spanned 4 decades and 3 major American cities. She attended Long Island University, earned graduate degrees from Pace University and New York University, eventually accumulating honorary doctorates from several different institutions. Her professional rise was exceptional by any measure. Classroom teacher, principal, regional superintendente, then district chief executive in Cleveland from 1998 to 2006, followed by work as an academic officer in Detroit, and ultimately her appointment as CEO of Chicago Public Schools by Mayor Rahm Emanuel in 2012. Chicago's system served nearly 400,000 students, mostly from low-income families in one of the country's most financially pressured districts. In 2009, the American Association of School Administrators named her National Superintendent of the Year. She arrived in Chicago with the full institutional weight of that honor behind her, with Mayor Emanuel's public confidence and a reputation built on decades of advocating for children in underfunded school systems. She was 62 years old, presenting herself in every public forum as a seasoned reformer with an exceptional and unshakable record in urban education. The scheme she had already constructed, or was in the process of building from the moment she arrived, worked as follows. Before her appointment at CPS, Byrd Bennett had served as a paid consultant for 2 suburban education firms, Supes Academy and Sini Associates, both based in the Chicago suburbs and owned by Gary Solomon and Thomas Veras. Upon her arrival, Byrd Bennett steered no-bid contracts worth more than $23 million to those 2 firms. These were contracts for principal training and professional development services. They bypassed all competitive bidding requirements and the district's own disclosure policies. On a CPS ethics disclosure form, she answered no when asked if she had any economic interest in entities receiving district contracts. That was a lie. In exchange for those lucrative contracts, Solomon and Veronis promised Byrd Bennett a 10% kickback. It was disguised as a signing bonus for when she left CPS, plus trust funds of $127,000 for each of her twin grandsons. Investigators later dug up a damning email Bennett sent to Solomon while the deal was active. It read, "I have tuition to pay and casinos to visit." She even ended the message with a smiley face. While she lined her pockets, her district was failing nearly 500,000 kids who had no other place to learn. Feds built their case using a mountain of email records, internal financial logs from the company, and the full cooperation of Solomon and Veronis, who both took guilty pleas on federal charges. The paper trail inside the firm was blatant. They even had a specific line item in the books, just to track her expected kickback. Solomon had been incredibly blunt in his messages, confirming her payout would drop on day one, making her, in his own words, the highest paid person on earth for that single day. Luckily, the feds intercepted the scheme before the money could ever change hands. But the paper trail, the rigged contracts, and the lies on her ethics forms gave prosecutors everything they needed to prove the fraud. That email chain and the company's own records, plus those $23 million in no-bid contracts, left absolutely zero room for doubt. On October 13, 2015, Bird Bennett walked into federal court and pleaded guilty to wire fraud. During a tearful hearing, she admitted that the children of Chicago deserved much better than what she gave them. At her sentencing in April 2017, prosecutors pushed for 89 months behind bars. Her defense team begged for just 3.5 years plus community service. Judge Chang handed down a sentence of 54 months. She began her 4.5-year term at a federal prison camp that August. By May 2020, a pandemic-era policy from the Justice Department changed everything. She was released to home confinement in Ohio after serving less than 3 years, classified as a non-violent offender at risk. A later investigation in 2021 uncovered even more corruption that the feds hadn't even touched, including another contract worth tens of millions that was rigged for a friend. It described her time in office as one of the most shameful abuses of public trust in the city's history. As for Gary Solomon, the mastermind behind the whole scheme, he was sentenced to 7 years. The students in those crumbling, underfunded schools were left behind long after Bennett walked away. She gutted the very institution meant to protect those kids, all to fund her casino trips and a bonus. While Bennett's crimes were committed through paperwork and wires, this next case shows what betrayal looks like when it gets behind the wheel. Let's look at John Harold Mackle. What really disturbed investigators wasn't just what happened at that house in Lithonia, Georgia, at 1:45 a.m. in March 2014. It was the calculated steps he took before he ever arrived. Every email record, phone log, and piece of testimony from his federal trial represented a clear moment where he could have made a different choice. But he never did. Not once. Task force investigators in Atlanta, working with the FBI, had already tracked his every move before he even backed out of his driveway. John Harold McKill had been a respected school principal in Douglas County, Georgia, for 16 years. His most recent assignment was at Mount Carmel Elementary. He was 57 when the law finally caught up to him in March 2014. His career in the Douglas County District stretched back to 2004, and official records show he had served as a principal in other schools, including at least one out of state. To his colleagues, he was just a seasoned, experienced administrator. His official personnel file was completely clean. No complaints, no disciplinary issues, nothing to raise a red flag. He had passed every single background check required throughout his long career in education. He was a married man and a stepfather to 3 kids. They lived a quiet life in Villa Rica, just outside Atlanta. The families near Mount Carmel weren't wealthy. They trusted that school with something truly irreplaceable, their own children. And every day, that sacred trust rested on the professional judgment of the man in charge. Let's look at the evening of Saturday, March 1st, 2014. A Craigslist ad appeared in the casual encounters section. It looked like a mother seeking a man for her 13-year-old daughter's sexual introduction. In reality, a task force officer placed the ad. It was part of a coordinated, multi-agency undercover sting operation. They called it Operation Broken Heart. The sting involved 37 law enforcement agencies and led to 14 arrests over 4 days in early 2014. That Saturday night, McGill took the bait. He messaged the undercover officer, thinking she was the girl's mother, through a series of emails and texts over several hours. The digital record showed McGill boasting that he had plenty of experience in these situations. He claimed he'd taught other girls before and promised to go slow. His wife was away at a conference. After putting his own kids to bed, he drove 50 miles across Atlanta through the darkness of the night. He arrived in Lithonia around 1:45 a.m. on March 2nd, carrying a condom in his pants pocket. But he wasn't met by a mother. An FBI task force officer was waiting for him at the door. The police placed him under arrest right there. By May, federal prosecutors in Georgia indicted McGill for using the internet to attempt the enticement of a minor. The entire indictment was built on a documented, undeniable digital trail. Those emails and text messages clearly established McGill's dark and criminal intent. He knew the victim's supposed age and made the deliberate choice to drive to the meeting spot. The two-day trial began in December 2014 before United States District Judge William Duffy Jr. Prosecutors laid out the complete electronic record of every communication McGill had with the undercover officer. They presented cell tower data tracking his location and the physical evidence recovered during the arrest. The defense argued that no real child was ever harmed, which was factually true. However, that doesn't matter under the federal enticement statute. The law only requires proof of the defendant's intent and actions. The jury deliberated and returned a conviction. In April 2015, Judge Duffy sentenced McGill to 10 years in federal prison plus lifetime supervision. It is important to remember that federal law doesn't require an actual victim to exist. The crime is committed through intent and the steps taken to act. The evidence proved both beyond any shadow of doubt. McGill had served as a school principal for 16 years. He'd passed every background check. Every single day, he was trusted with the lives of elementary school students. Parents brought their little ones to his building every morning, believing they were safe in his care. On the night he fell, his own stepchildren slept peacefully while he vanished into the Atlanta night, heading toward a target 50 miles away. There was no ambiguity in that federal courtroom. The evidence was a cold sequence, a post, a response, a negotiation, a drive, and an arrival. Every link was recorded before he reached the door. The acting United States attorney called it a total betrayal. Prosecutors described his conduct as deeply disturbing and a violation of every public trust his position required of him. By the time the trial concluded, Mount Carmel had already moved on with a new principal. McGill's name was wiped from the school records after that night in March. You and I are examining two cases in this documentary involving elementary school principals who attempted nearly identical crimes. This is the first. The second case is just as deliberate. Let's move to Case 7, Beverly Hall. A statistical study published in 2009 first identified a strange pattern in Atlanta's competency tests. The results didn't match what experts expected from normal fluctuations in student performance over time. Scores had risen in massive, extraordinary jumps, school by school and year by year. It was a rate of improvement unseen in any other comparable urban school district in the country. Let's look at how a newspaper's data team sparked a 2-year investigation by the Georgia Bureau of Investigation. It spanned dozens of schools. Hundreds of educators were involved in a decade of deception, all tracing back to the culture inside the superintendent's office. Beverly Hall was born on July 7, 1946, in Montego Bay, Jamaica. She built a career in some of the largest and most demanding public school systems in the United States. She earned her undergraduate degree from Brooklyn College in 1970. After finishing her graduate degrees at Fordham University in 1990, she climbed the ranks of the New York City schools. She worked as a teacher, principal, and coordinator before moving into administration. She served as the superintendent of schools in Queens before taking over the Newark public school system from 1995 to 1999 after the state took control. In 1999, she left Newark to become the new superintendent of the Atlanta public school system. She arrived to find fourth graders lagging 20 points behind in math and a district facing 700 teacher vacancies. The district had cycled through 4 leaders in a decade, but Hall was soon hailed as a leader who saved it from failure. Atlanta's fourth grade math scores began to climb. Between 2002 and 2009, 8th grade scores showed some of the highest gains in the country, while teacher vacancies dropped from 700 to just a handful. The National Education Establishment took notice. In 2009, she was named National Superintendent of the Year, an honor described as the equivalent of a Nobel Prize in her field. Reports later showed she received over $500,000 in bonuses, all tied directly to the test score gains she supposedly produced. As you and I will see, those gains were manufactured, leading state investigators to a massive, chilling conclusion in July 2011. Investigators looked at 56 schools and found evidence of cheating in 44 of them. The scheme was systematic, with answer sheets being erased and corrected by staff after the students had finished their tests. At some schools, teachers even held what they called erasure parties. These were organized sessions where booklets were collectively worked through and corrected. Wrong answers were replaced with right ones, involving 178 educators who either participated or looked the other way. Investigators discovered this corrupt culture wasn't an accident. It was a carefully constructed system. It was built on a framework of relentless pressure. There were severe consequences for any principal or teacher who failed to hit their targets. Those who tried to report what they saw faced documented retaliation from above. The official report described Hall's environment as a culture of fear, intimidation, and constant threats. This allowed cheating to go unchecked for years. A former human resources director named Millicent Few eventually cooperated with the prosecution. She testified that Hall ordered the destruction of documents that would have exposed the cheating much earlier. This order wasn't just misconduct. It was a deliberate attempt to bury the evidence of a crime. This led to a 65-count indictment handed down by a grand jury on March 29th. In 2013, the indictment named Hall and 34 other current and former Atlanta educators. Hall faced charges of racketeering, theft, and conspiracy to influence witnesses. She faced a sentence of up to 45 years, though her attorneys insisted she never had any personal knowledge of the cheating or directed it herself. Eventually, 21 defendants pleaded guilty and agreed to help the prosecution. The remaining 12 went to trial in 2014, with prosecutor Fonnie Willis leading the case. Hall's trial was separated from the others and delayed multiple times. By late 2013, she had stage 4 breast cancer, and doctors told the court she was simply too sick to stand trial. The trial for her co-defendants finally wrapped up in the spring of 2015. On April 1st, 2015, 11 of the 12 defendants were convicted on racketeering charges. Several were sentenced to prison, but Beverly Hall did not survive to hear those verdicts. She died at her home in Atlanta on March 2nd, 2015. She was 68 years old, and a verdict was never reached in her case. The charges against her were officially dismissed after her death. Her legal team maintained to the end that she would have been acquitted if she had been given a fair trial. Between 2005 and 2009, students in Atlanta were told they were performing at grade level, when, in reality, their test scores were being systemically rigged. Under Hall's leadership, every academic record became a complete fabrication. Crucial help never came for these kids, because the fake data claimed they were doing just fine. The damage was not abstract. It was real, measured in the gap between a child's record and their true knowledge. Today, let us look at a case involving a school building much smaller than any major urban district. But the betrayal here was just as deep. This is Case 8, Boyd Holler. A digital trail slowly pointed investigators toward the principal's office at Pioneer Elementary School in Somerset. In California, a joint operation by the FBI and local prosecutors began to uncover a dark online secret. The investigation focused specifically on suspicious online communications involving minors. Investigators identified a pattern of contact originating from accounts traceable to one location sometimes, the school building itself. His arrest on October 17, 2023, came without warning. No rumors, no complaints, just total shock. This was a community that had absolutely no reason to doubt the man they saw being led away. At 37 years old, Boyd Holler seemed like the perfect model of a citizen. Living in Pollock Pines, California, his career had grown steadily from a classroom teacher to a respected leader. He taught in Camino for years before making the leap into school administration. Eventually, he worked his way up to become an assistant principal in the area. Records show his climb was complete by 2017, when he became the principal of Gold Trail School. By the time of his arrest, he had moved to the principal's post at Pioneer Elementary in Somerset, a rural town in the Sierra Nevada foothills. This small district was a place where families relied on close, personal bonds with their local educators. In a town like this, everyone knows every child's name. That intimacy usually creates a deep sense of personal accountability. Local parents later described him as someone who presented every outward sign of being a trusted, professional, and dedicated community educator. The district superintendent learned of the arrest the very day the news finally went public. They stated that Holler had been placed on immediate administrative leave and clarified that no students in the district were identified as victims in the investigation as it stood then. Court filings revealed a dark trail of activity that stretched across the entire month leading up to his arrest. Back in September 2023, Mahaler made contact through the messaging app Kik with someone he believed was a 12-year-old girl. The girl was very clear about her age, claiming she was a 7th grader living over in Philadelphia. Even after seeing photos that confirmed her young age, Haller chose to keep the conversation going anyway. He allegedly sent explicit photos and videos from several different spots, all across El Dorado County. Court records show he used graphic language to describe the specific acts he planned to commit after, in his words, kidnapping the girl and arranging a secret meeting with her during the upcoming Thanksgiving school break. Prosecutors noted in their filings that these conversations were not just held from his home in Pollock Pines. The activity occurred at the Pleasant Valley Holiday Market and right inside his principal's office at Pioneer Elementary, using a device connected to the school network during his working hours. Documents from the El Dorado County District Attorney's Office laid out the facts plainly. Despite his outward appearance as a pillar of the educational community, the filing read, Haller reportedly hid a dark sexual interest in children that he had kept secret for a very long time. Investigators also identified contact with at least one minor living in the United Kingdom. Procedural details on that lead were limited during the hearing, but court filings suggested the scope was much larger than initially thought. The records also referenced specific statements Haller made during his communications with others. These included alleged interactions with students in his office, claims that investigators were still racing to verify during his arraignment. At his arraignment on October 19, 2023, Haller pleaded 4 counts of distributing pornography to a minor with the intent to groom them, and 4 more for contacting children with the goal of committing a sexual offense. Prosecutors from the El Dorado County District Attorney's Office fought to keep him behind bars without bail. Prosecutors filed documents warning that he was a flight risk, dangerous to children, and prone to self-harm. Bail was denied in the following weeks, but the FBI task force continued a deep forensic dive into his devices. On December 11, 2023, Haller changed his plea to guilty on 2 of the major criminal charges. These included distributing pornography to a minor and contacting a child for the purpose of a sexual offense. The court conducted his sentencing on January 22, 2024, in El Dorado County. Haller was sentenced to 3 years and 8 months in state prison, the maximum term allowed under California law. Lifetime sex offender registration was mandatory. The Pioneer Union School District confirmed that he would never return in any professional role. His previous post at Gold Trail School was part of a history that each employer had vetted through legal background checks. None of those mandatory investigations had returned a single adverse finding. The school in Somerset, where those messages were sent, remained open under an entirely new administration. Most families did not hear about the arrest from the district. They found out through other channels. Social media was buzzing with the district attorney's press release, long before the school issued its own notice. California Governor Newhom signed Max Benson's law in January 2024. It was signed the same month as Haller's sentencing, a coincidence that felt deeply significant to the community. 2 separate school tragedies in the same county were resolved within just a few weeks of each other. One principal restrained a student until he died, while the other is our current case, together revealing a pattern far too disturbing to be ignored. Case 9, Stan Myers. An incident report filed on November 28, 2018, was what finally forced state regulators to act. By law, schools must file this document whenever a physical restraint results in a serious injury or death. It revealed that a student at Guiding Hand School in El Dorado Hills had stopped breathing. He went limp during a prone restraint and was rushed by ambulance to Mercy Hospital in Folsom. The department's initial review of that report flagged 2 massive procedural failures almost immediately. The school failed to provide written notice, and their story did not match what witnesses were saying. This gap in the story launched the investigation that would eventually turn into a major criminal case. It took nearly 7 years for this investigation to finally reach a sentence. Guiding Hands was a private school for kindergarten through 12th grade, operating out of a local California business park. The institution had been in operation for 25 years. It was state certified to serve students struggling with behavioral issues and various developmental disabilities. This status allowed the school to take in students from public districts that could not meet their needs. These students came from across the Sacramento Valley, because their complex needs could not be met in standard classrooms. You and I should note that over 100 students from 22 districts were enrolled at the facility. Each child was placed there through special education plans and contracts signed by their home districts. We are talking about some of the most vulnerable children in the entire Northern California school system. Severe developmental challenges. Their complex needs made regular classrooms impossible, and they were sent to guiding hands because the facility promised it was equipped to help them. Stan Myers served as the school's principal, overseeing all daily administrative operations. She was responsible for staff training and the rules that governed how teachers could physically intervene with students. Her rank put her at the very top of the school's oversight structure. She was the administrator whose decisions determined how staff were trained and when restraints were actually authorized. Her standards defined what was acceptable care when a student became upset or stopped following directions. Max Benson was 13 years old and autistic, having been enrolled at the school just months before November 2018. On November 28th, it was the day before Thanksgiving when Max spat on another student, and staff moved in to restrain him. They pinned him face down on the floor in a prone position, with staff members applying pressure to hold him down. The state investigation and later civil lawsuits focused on one horrifying detail: the duration of the incident. For more than 90 minutes, Max was pinned down in that same position. Witnesses testified he stopped resisting long before it ended, and that he eventually lost control of his bodily functions while still being pinned down. Staff finally placed a call for the school nurse to assist. Court records and the family's lawsuit show the nurse failed to respond for 10 agonizing minutes after being called. It took approximately 25 minutes from the initial discovery before anyone actually called for paramedics. First responders rushed him to Mercy Hospital in Folsom before transferring him to UC Davis Medical Center in Sacramento. He was declared brain dead the next day, passing away on November 30th, 2018. State officials pulled the school's certification, citing major violations in how staff handled physical restraints. They ruled the force used was neither reasonable nor necessary given the actual circumstances. Investigators found that staff ignored numerous state laws meant to protect students with disabilities. By early 2019, the school had permanently closed its doors. In November 2019, prosecutors charged Administrator Cindy Keller and teacher Kimberly Woolwind with serious crimes. Woolwind, the staffer directly involved in the restraint, faced charges of felony involuntary manslaughter. The school corporation itself was charged as an entity. All three parties entered pleas of not guilty. The legal case then stalled, trapped in years of rescheduled hearings and procedural delays. Continuances were granted, and the case stalled for years while the family waited. Finally, a grand jury indicted the three in 2022. A trial date was eventually set for May 27, 2025. But it never happened. In mid-May of 2025, the defendants entered surprise pleas. Keller and Myers both entered no contest pleas to misdemeanor child abuse. Woolwind pleaded no contest to felony involuntary manslaughter a week later. Sentencing was moved to June 16, 2025, in the County Superior Court. The courtroom was packed, overflowing with local residents and advocates for the disabled. The family's lawyer argued that the school had fostered years of abuse against its most vulnerable children. After hearing the emotional impact statements, Judge Mark Ralphs initially hesitated to accept the plea deals. He postponed sentencing, stating he needed more time to decide if the agreements were actually justified. A new date was set for August, and the judge eventually allowed the plea deals to stand. The final terms gave Stan Myers 4 years of probation with no jail time. Keller received the same sentence. Woolwind was sentenced to 2 years of probation and a child abuse prevention program. The Benson family was reportedly left devastated. Max Benson's legacy lived on through the creation of Senate Bill 483. Signed in early 2024, this law banned prone restraints in all California schools following his death. This legislation completely overhauled safety standards for every single school across the state. Yet the sentence given to the principal who ran the school didn't match the scale of the tragedy. Our final case involves no violence. No midnight highway, no physical struggle, just a laptop, a school network, and a dark choice. This was a crime hiding in plain sight. This is Case 10, Edward Bonnick. The hunt for Edward James Bonnick didn't start with a tip or a witness, it started with a digital signature. Local detectives and Homeland Security were busy monitoring file-sharing traffic on the web. They were tracking file-sharing activity to identify IP addresses used to send and receive illegal child sexual abuse material. By the spring of 2018, one particular New Jersey 1P address kept flagging their system. By the time investigators finally traced that address back to its owner, a disturbing pattern emerged. They documented a pattern of sharing that had been going on for months and began coordinating with multiple law enforcement agencies. The digital trail led directly to a laptop issued by a local school district. That device belonged to none other than the principal of Pleasantville High School. Edward James Bonek had been in the public school system for 23 years. He was 50 years old at the time of his arrest. He had worked through the district in several roles, starting as a teacher. He served as assistant principal, then interim principal in 2016, before taking over the full-time role in 2017. Bonek had just completed his first full year in that role when detectives arrived at his home on August 8, 2018. Records later confirmed his exact annual salary at the time he was taken into custody for these crimes: $130,964. The money was drawn from public funds in a district that served a predominantly low-income student population in Atlantic County. Pleasantville had entrusted him with that paycheck to lead their high school and watch over their children every day. The school laptop he used was provided to him by that same community for that very same purpose. As investigators executed a search warrant at his Absecon home on August 8, 2018, they focused on his electronics. They seized the school-issued laptop and examined its contents, documenting over 1,000 images and videos of child sexual abuse and exploitation. The illicit material had been downloaded through the BitTorrent peer-to-peer sharing network. This software functions not just as a download tool, but as a system for simultaneous automatic distribution. Files placed in an active sharing folder on a BitTorrent client are automatically made available to every other user on the network at the same moment. His laptop's sharing folder was active. Bonek was not simply a consumer of this material. He was transmitting files to other users from the device provided to him by the school district to educate local children. Assistant Prosecutor Dave Rufinak stated at the hearing that the associated IP address had been active for several months. His activity had reached numerous law enforcement agencies, meaning investigators from different areas were independently flagging the account. Multiple jurisdictions had independently flagged that same address before the entire case converged into a single prosecution. While investigators searched his house, Bonek admitted that he owned the illegal material and that he had been using the BitTorrent network. At a detention hearing on August 14, 2018, he appeared before Atlantic County Superior Court Judge Benjamin Podnick. Defense attorney John Zarek argued that his client had no idea the downloaded files contained such disturbing child abuse material. He claimed he was only trying to download adult material and that the illegal content arrived without his awareness or review. The attorney described the case as the thinnest distribution matter he had encountered in a very long time, and the judge's response was direct. Is this a fake child pornography case? He ordered Bonek held without bail, calling his habit of bringing the laptop to school a tragic breach of community trust. The judge observed that the files on the device were not locked or secured in any way. Anyone who accessed the computer while the principal stepped away could have easily stumbled onto those horrific images. He tried to appeal his detention, first through the state appellate division, but found no relief there. The New Jersey Supreme Court also denied his request. He remained jailed from that day in August onward. Bonek was finally indicted on October 23rd. In 2018, he was indicted on multiple first-degree counts of child endangerment for possessing and distributing abuse material, along with intent to distribute. He faced charges for maintaining a file-sharing system and official misconduct for using a district-issued device to commit these crimes. He also faced a separate charge for the illegal assault rifle discovered by investigators during the search of his residence. He initially pleaded not guilty in December 2019, dragging the case out through a year of pre-trial motions. Eventually, Bonek changed his plea and admitted to child endangerment through possession and distribution, along with the unlawful possession of an assault rifle. Under the final plea agreement, he was forced to permanently give up his teaching and principal licenses. On February 7, 2020, Atlantic County Superior Court Judge Donna Taylor sentenced Edward James Bonek to 8 years in state prison with 5 years of parole ineligibility. A concurrent 5-year term was imposed for the assault rifle charge, along with an additional 3.5 years under the state's strict firearm laws. He faced lifetime registration under Megan's Law and permanent parole supervision. Bonnick had served about 18 months in pretrial detention before his sentence was officially handed down by the court. He entered state prison in 2020 and was released in September 2023, now subject to lifetime supervision. His teaching and principal licenses were gone. He had spent nearly a decade as an educator in a community whose children he was paid to protect. He carried a device meant for their benefit, using it to betray them. He used his access to share recorded abuse of more than 1,000 innocent young victims. A digital trail sparked the investigation. It ended by permanently stripping this man of every single position of authority he was ever granted. The weapon used against the children in his community was something no one could actually see. It was issued to him by name, delivered to his desk, and trusted to stay in his hands. 10 cases, 10 offices, and 10 people tasked with guarding the one institution built to keep children safe. Their crimes were all different, yet the power they held while committing them was exactly the same. These stories share more than a crime pattern. They reveal a cycle of broken trust and the children who paid the price.